If it pleases the court, my name is Jahar, initial T, and I appear as junior counsel for the defendant, the Quixley Hotel. It is my submission that the defendant cannot be found to have caused the harm of the plaintiff, as the necessary elements of factual causation and scope of liability have not been met in accordance with Section 11.1 of the 2003 Civil Liabilities Act. Submission 2.1. The High Court in the 2009 case of Adil's Palace and Mubarak found that the but-for test was the necessary test for causation in all but an undefined group of exceptional cases. In that case, the court found that as the harm to the plaintiff might still have occurred without the breach, the application of the but-for case in accordance with statute failed to prove causation. Should this court find that the defendant had a duty of care to eject Conrad and Keith on the basis of their displayed aggression, the punch delivered to the plaintiff fails to meet the condition of factual causation. Applying the but-for test to the facts, Eleanor may still have punched the plaintiff but for the ejection of Conrad and Keith. In submission 2.2, there is nothing on the facts to suggest the provision of extra security personnel would have prevented Eleanor from pursuing her irrational assault of the plaintiff. A similar set of facts presented themselves in the 2009 decision of the High Court of Australia, where the court found of Adil, Palace and Mubarak, where the court found that there was no evidence that extra security staff would have prevented an armed gunman from pursuing his irrational, intentional act of revenge. The conditions for factual causation, I submit, are therefore not met. Submission 2.3. The criminal act of punching the plaintiff is a novus actus interveniens, and the defendant cannot be held liable for such harm, even if the risk of violent assault was foreseeable by the defendant. His Honour Chief Justice Gleeson in Modbury Triangle Centre and Ansell said that the unpredictability of criminal behaviour is one of the reasons why, as a general rule, and in the absence of some special relationship, the law does not impose a duty to prevent harm to another from the criminal conduct of a third party, even if the risk of such harm is foreseeable. Submission 2.4. The probability that the plaintiff stepped upon the coaster is in equal measure to the probability that they didn't just immediately before their fall. Given that the facts show no conclusive evidence either way, factual causation is not proven. Your Honour, a similar set of facts presented in the 2013 New South Wales Court of Appeal case, Coles Supermarkets Australia and Meneghello. In that case, it was alleged that a chip on the floor caused the plaintiff to fall. However, the court found that there was no evidence to suggest that the two relevant possibilities, one that the chip caused the fall, the other that it did not, were not equal in measure, and consequently no factual causation of harm could be found. With respect, I submit no factual causation in this instance. In the 2008 Queensland Court of Appeal case of Ellis and Uniting Church in Australia Property Trust, the court held that the injury of Ellis was caused by his own carelessness. The facts in this case show that the plaintiff was not paying attention before she decided to move away from the bar immediately before she slipped and fell. With respect, I submit that the subsequent injury was not caused by any breach of duty by the defendant, but by the inattention of the plaintiff. Submission 2.6. In the 1961 Privy Council case between Overseas Tankship and Morts Dock and Engineering Co., reasonable foreseeability was indicated by Your Honours to be an essential factor in determining the scope of liability. With respect, I submit that a reasonable man could not foresee that the failure to either collect a piece of cardboard from a fall or eject intoxicated patrons from an establishment with a long history of peaceful trading would set a chain of reaction of events that would result in the psychological harm of the defendant. If the court finds a breach by the defendant, the resultant psychological harm suffered is so remote as to fall outside the scope of liability of the defendant. With regard to the above submissions, counsel for the defendant respectfully requests that Your Honour finds in favour of the defendant, the Quixley Hotel, with costs awarded to the plaintiff.